Raising a family can be difficult, and sometimes families need help to make children have a safe home. When someone has a concern about the health or well-being of a child, a county social worker, as seen here, is usually contacted. After that, sometimes the Juvenile Dependency Court will become involved. Juvenile Dependency Court is not a criminal court and is not about punishing the parent. Judges, lawyers, child protection services, and treatment providers are committed to providing safe, nurturing, and permanent homes for children, while at the same time giving parents the support and services they need to be able to provide a safe home for their children. It is important for parents to get involved in their services and treatment as soon as possible to help reunify their family. This video will introduce you to some of the things that you are likely to find if you have a juvenile dependency court case. 4-year-old John and 2-year-old Teresa are like many children involved in the juvenile court. The lawyer for the children usually meets with them before the first court hearing. They have been removed from their home and are staying in an emergency foster home. In many cases, the first hearing is called the detention hearing or initial hearing. It is the first time that your family will be in court on your dependency case.
Hi, it's really nice to meet you.
Parents, legal guardians, and children have a right to have a court-appointed lawyer represent them in dependency court. These are lawyers licensed by the state bar who have the skills and specialized training to represent people in dependency court.
This is a detention petition.
John and Teresa's parents receive a copy of the petition at the detention hearing. Mom's lawyer is going over the petition with her. At this point in the case, Dad has not yet been provided a lawyer because his status as a biological or presumed father has not yet been established. The petition is the court document that lists the reasons why the social worker feels that the children are at risk or have been harmed. Because these things haven't been proven yet, they are called the allegations. Parents have certain rights at the detention hearing. The detention hearing is also a time to gather information about your family. The social worker will prepare a report about your family. The social worker is required by law to ask about parents, relatives, and friends who have a connection to John and Teresa.
Brothers or sisters.
If a relative or family friend can be approved by the social worker, then John and Teresa can live with them. If a relative or family friend cannot be identified, John and Teresa may have to go and live with people they do not know, like a foster family. Foster families are licensed by the state and must meet strict standards in order to have children placed in their homes. The social worker and judge will also ask if the family is a member of a Native American tribe. For family members that are a part of a tribe, special laws apply. The decisions that the judge makes at the detention hearing are temporary until the jurisdiction and disposition hearing. Sometimes people meet outside of the court to come to an agreement, like in mediation. At mediation, people like the child's attorney, mom's attorney, mom, dad, the social worker, and county counsel who represents the social worker may come together to work on a solution that is best for the children.
Jurisdictional report.
The family receives a report from the social worker. The report tells the judge why the social worker thinks the allegations are true and why Teresa and John are not safe living with their parents right now. Teresa, John, and their parents are back in court for the jurisdiction hearing. This is the only hearing where the court will hear facts about why the family was brought to the court's attention. At the jurisdiction hearing, the judge decides if the allegations in the petition are true or not. If the court determines the allegations are true, the case moves forward.
Thank you.
Sometimes the best option is to resolve matters outside of court. It is important to talk to your lawyer about all your options. The options for this important hearing are complicated, and the choices you make will have a critical impact on your case. It is very important to talk to your lawyer about the options at this hearing, which include admitting to the allegations, submitting the report to the court, pleading no contest to the allegations, or contesting the jurisdiction allegations. It may be necessary to have a trial where witnesses would take the stand and give formal testimony to the court. At a contested jurisdiction hearing, the parents have the right to testify themselves and present their own evidence for the judge to consider in making his or her decision. Testifying means that a person tells their story to the judge. The person that is testifying also has to take an oath.
Yes.
The oath is a promise to tell the truth to the judge. The parents also have the right to cross-examination. This means that the parents, through their lawyers, can ask the witnesses questions. Children are also able to ask questions through their lawyer. Sometimes children answer questions from the judge, depending on their age.
I've reviewed the
At the end of the jurisdiction hearing, the judge can decide that there is not enough evidence to support the allegations and dismiss the case. But in Teresa and John's case, the judge decides that the allegations are true. The judge can now make decisions about where Teresa and John can live and who can visit them. This hearing is called disposition. The judge will also make decisions about the children, such as authorizing their medical care and ensuring that their education needs are met. At the disposition hearing, the judge can order the parents to participate in services to help them reunite with their children. Sometimes the jurisdiction and disposition hearings are held on the same day. Part of the disposition hearing is for the judge to consider a plan for the family. The most common plan in juvenile dependency court is family reunification. This means that the judge can place Teresa and John with relatives or another family and order the parents to participate in services to get the children back into their care. The services that the judge orders are described in a document called the case plan.
Thank you for coming.
The case plan is like a roadmap that gives the family directions on how to reunite. The case plan lists the services that will assist Teresa and John's parents with the issues that led them into court. Services may include drug treatment, counseling, and a plan for when the children and parents can visit each other. The children and parents can talk to their lawyers about the plan, but remember, it is the judge that makes the decisions. Teresa and John, like most children, want to return home as quickly as possible. Under the law, Teresa and John's parents most likely have 12 months to show the judge that they can safely parent their children. One way that parents can show that they can safely parent their children is by actively participating in their services and trying to learn as much as they can from the classes they attend. Teresa and John's parent is attending an intake appointment for counseling. The social worker will contact the counselor before the next hearing and ask if the parent was accepted into counseling and is attending her sessions. This progress will be reported to the court. Special timelines exist for children who are under 3 years of age at the time of removal. You can ask your lawyer about these. If Teresa and John cannot safely return to the home of their parents within the time allowed, then the court can end reunification services for the parents and set a hearing to select a permanent plan for the children. The judge will continue to see your family in court. These are called review hearings. There are several types of review hearings. Let's focus on the status review hearings.
Hello, Michelle.
Michelle, who is 10 years old, is in court for her first status review hearing. Because of her mom's dependency on drugs and her father's violence, Michelle was removed from her home and placed in a foster home. Status review hearings are required by law to happen every 6 months. At these review hearings, the judge must consider whether or not to return the children home to their parents. The social worker will prepare a report with recommendations to the court. The parents and sometimes the children will go over this report with their own lawyer. It is very important that parents plan to attend these court hearings. Michelle talked to her lawyer and told him that she wanted to come to all the court hearings. It is a good idea to come to court hearings if you can, because important issues are discussed at the hearing, such as how often the family can visit and where the children will live and go to school. Michelle meets separately with her lawyer to go over the first 6-month review report. Michelle is having a hard time in the foster home and wants to go home. The report recommends Michelle stay in foster care and continue to visit with her mom. A lawyer for children in juvenile dependency court has 2 jobs. One is to tell the judge what the children want, and the other is to tell the judge what is in the child's best interest. The lawyer will tell the judge that Michelle wants to go home, but because her mom is still struggling with her drug addiction, it is not safe for her to return at this time. However, he will tell the court about Michelle's issues in the foster home and ask to schedule more visits with mom. Mom also talks to her lawyer about the report. Mom does not agree with everything in the report, but admits that she is still struggling with her addiction and is willing to participate in more services to have Michelle return to her care. If a parent seriously disagrees with the content of the report, they are entitled to have a contested hearing or allowed to inform the court of what corrections they feel need to be made.
This is the matter.
If the family is allowed to receive more than 6 months of services, the next status review hearing is held 6 months later. Like the first 6-month hearing, the options for the judge to consider for Michelle at this hearing include returning Michelle to her mom's care or terminating reunification services for mom. For Michelle, things are going well, and the judge orders her to return to her mother's care. The judge can continue to monitor this family to ensure Michelle is safe in her mother's care. Sometimes cases do not end like Michelle's. Sometimes the judge makes the decision that children cannot go home to their mom or dad. In these cases, the judge must set a special type of hearing to choose a permanent plan for the children. When parents do not complete their reunification services, the judge has to come up with another plan for the child. This plan is determined at the hearing to choose a permanent plan for the child. The judge has 3 options at this hearing. The judge can order that the rights of the parents be terminated and these children be placed for adoption, order legal guardianship, which gives the foster parents the ability to make decisions for the children, but visitation can still be offered to the biological parents, or order the children to stay in foster care as the permanent plan. The goal of juvenile dependency court is to place children in a safe, nurturing, and permanent home. Hopefully, that safe, nurturing, and permanent home is back with their parents. But when it's not, dependency courts are committed to finding the best and safest alternatives for the children. If you find yourself in juvenile dependency court, remember to ask your lawyer questions if you do not understand, ask your social worker what you need to be doing, and take an active role in the process. Show up on time for court hearings and get the most out of any services provided to you. Participating in services early in the case not only shows that you are committed to the process, but can also be a positive experience that may help you in general as you move forward.